The 5 men accused of killing soccer star Senzo Meyiwa have once again pleaded not guilty to the charges against them. The trial, of course, as you know, we told you here on the show yesterday, is starting over. There have been questions raised in this regard, and let's try to get some answers now. We're joined by Nthabiseng Dubazana of Dubazana Attorneys. Thank you so much for your time this evening. Is it all bad that it is starting over again?
Not necessarily. I think when we look at the way that the trial commenced on the last occasion, it seems, for example, the docket content wasn't disclosed properly. If we recall, when Advocate Defo was still part and parcel of the matter, he brought to light during the state's case that there's a second docket that was not disclosed to the defense attorney, so there had to be applications to be dealt with during the trial. There were issues in terms of media, in terms of how the witnesses should be or should not be recorded, and those things had to be dealt with within the trial. There were no 220 admissions like there are now, so which means there was no proper pre-trial conference that was dealt with. So it is very impressive, I think, that the way that this one has started, it started first with the 220 admissions, which means that as a result, everything that has been submitted in terms of Section 220 of the Criminal Procedure Act, we're not going to deal with it at all. It's admitted. We're not going to test that evidence. It's going to go ahead as is. The only thing that we're going to deal with is obviously the identity of the people who either who committed the murder, who committed the robbery, and who committed the assault on the persons that were listed in the charge sheet as it was read out to the accused persons today.
So what does it then mean when it comes to the second docket that we kept on hearing all about, and you've mentioned it right now? Can that issue come up, or has it been ironed out as well in the pre-trial conference?
I think this time it was ironed out in the pre-trial conference because thanks to the way that the matter was dealt with initially, those issues were finally canvassed and dealt with. And so all the defense attorneys had the required documents to move on with this matter. That's why in the charge sheet, the way it was read out today, it was very specific to say, for example, that the current witness was injured in this manner and that manner. That was not there in the first instance when the charges were read out. So it means that whatever information that was dealt with in the second docket has now been incorporated into the charges that are being dealt with now in the new matter. And moreover, there were issues in terms of gathering of evidence. The photographer was supposed to come and testify in the previous case because there were issues on how things were moved and how they were not moved and all of those things. But this time they fall part of the 220 admission, so they're not going to canvass all of that. The only things we're dealing with is the actual elements of each of the crimes that they were dealt with. So intention, unlawfulness, the act itself, and then possibly negligence as a competent verdict for for murder. And for robbery, competent verdict would be that of theft and all of those things. So at least there's a clear map forward on how to deal with this matter.
And given the fact that, this is a do-over, and I'm wondering, because I've also seen a number of people asking this question, that can the defense raise questions should a witness contradict themselves from the earlier version that they would have given at the beginning of the trial, the previous one, that is, and versus what they would be saying now? How do they begin to navigate these waters?
So absolutely not. So that the reason that the presiding officer was very clear in the way that he conducted the matter yesterday, he went through SCA matters that dealt with a matter starting de novo. I think it was intentional so that these questions, when they come up, when media or even normal persons, lay persons want to say, but in the previous matter, so-and-so said this, but why is it changing now? The defense attorneys literally have to block their mind from what was said previously and deal as if this is the first time they're hearing this evidence before them today. Same thing with the state. They can't say, wait, but when we asked you this in examination in chief in the previous trial, you said this. No, those things is completely nullified. It is gone. So you can't refer to it in any manner or form. only advantage to that is that you have a certain version from the from the witnesses that you can put down as a side note, depending on how they answer questions now. And then as a defense attorney, you know how to prepare your cross-examination based on what was happening previously, but you can't refer to it at all. You have to deal with what you're hearing in court today.
Doesn't it raise, credibility questions, and not for the lawyers? I'm talking about the laymen, people who are watching this on the sidelines, who are saying, but this is what we would have been watching and this is what we would have heard, and all of this is on the YouTube channels. So does it not raise credibility questions that you can't refer to some of the contradictions?
Oh, correct. So, I mean, for the layperson, you will see the things that and last time this was said, this time this is now being said. And as a result, you start wondering whether or not there is any truth to the matter. So I think it is important to note that when we look at the way that evidence was led in the first trial, the good part about it is that documentary evidence also, and pictures and all of that, at some stage they stopped showing them visually. So we can't say that last time in this particular picture she said this or she said that. So in a manner of speaking, we don't know fully. We don't have full disclosure of everything that was led in the first trial. We only have what we were allowed to see. But for a layperson, I do see where that will be a little bit of a problem, wherein we are seeing that things are not really making sense. It's as if the witnesses, now that they have a second opportunity to give their evidence, they're covering this and covering up that, bringing information that was never there in the first place. But now it lies in the hands of the defense attorneys to pick up these things versus, so it'll be the statement they make in court versus the statement that they made when they were arrested, and then try and suss out how they're going to get the truth out of the witness.
Especially because some of those statements were already under scrutiny as, the first trial was, in fact, continuing there. But let's see what happens with this one. Certainly a lot that we need to know and understand as far as the law is concerned. And thank you so much for putting us in the picture there. That is Nthabiseng Dubazana for Dubazana Attorneys.